participant. Anyone who is participating with me at 7 p.m. on Monday, that means really this in particular subject is very, very important for all of us. Wonderfully, we got more than 1,000 registrations for this webinar, and it shows the interest in the market. It shows the chartered accountants are interested. It also shows that the MSME entrepreneurs are interested. As I would say that this is this structure, this pre-packaged insolvency resolution process, this will actually eat away the entire processes like one-time settlement with the banks, restructuring, nursing, rehabilitation. All these processes would be would not be undertaken, because the banks would prefer that a committee approach is better, even for any kind of restructuring or one-time settlement. Also, the banks would be interested that the process should be monitored. It is being monitored by NCLT. It is having a judicial stamp over it. So this process would become very, very popular process in the coming days. In fact, today we in fact started our first PIRP case. We discussed with the entrepreneur, the MSME entrepreneur, and we discussed with him all the features, how this would never cause a loss to him, because there is no disruption in the business, and even if it fails, there is no risk of company going into liquidation. This is a process that one can try, and without even getting the knowledge of the public. The banks can definitely say that this is what we can do, this is what we cannot do, but this is only a preliminary. And this is in case there are bankers also connected with us today. I would say to them that initiating a PIRP process is not detrimental to their interest. Agreeing to base resolution plan in principle is not detrimental to their interest. At this stage, if a banker, if a financial creditor agrees to starting a PIRP process, there is no loss to banker. Ultimately, he may accept or he may not accept the resolution plan. Even the base resolution plan he can deny later on, saying that this base resolution plan is not acceptable to us, and nobody has come up from the public at large to bid for this company. So we would not be interested in this kind of either haircut or this kind of restructuring. So the bankers would not lose anything. The more so, the entire process, the entire PIRP is cost effective. The cost is very less for this, and there is no contribution to be done by the bankers. The contribution would be done, most of the contribution would be done by the corporate debtor, and the fee would be decided by the financial creditors. The appointment of RP would be decided by the financial creditors. However, the fee would be paid by the corporate debtor. So this is not an additional burden on the banks or financial institutions. They can definitely try and resolve the stress of an MSME by resorting to this process.
There's a request for you to speak a little loudly.
Okay. My connections are all okay. I think now I can. Okay, somebody is also saying that it is okay for him, but then yes, I would try to speak loudly. And I now shared my screen, and the Ankit, as you say that the model is the same, we would go by the same model. After every half an hour, we will be taking questions, because I understand that a lot of questions will come.
Yes, every half an hour we should take a Q&A.
Okay, so there are some people who have raised hands, so we would request them to write their question on the
Q&A box.
on a Q&A. See, otherwise, in case we will start taking the questions live, so then it will actually start a little different kind of discussions. So it's a totally an educational webinar, and we would only be focused on the procedure, process, regulations, rules, and we would also be able to understand the individual kind of eventualities. Somebody may ask a question like, in case this is a scenario, then how would it happen? If this is a scenario, how would it happen? So these kind of questions are most welcome. So in case anyone who would have questions like this, that's something which is giving kind of an illustration to the listeners and to the viewers. So we have discussed in the last part one, for which the part one for which the video recording is available on our YouTube channel, which is in the name of AAA Insolvency. So we had discussed earlier how this process would be initiated, and the MSME, the basic default amount of 10 lakhs, that has also been discussed. So one important part that I would like to reiterate, and for the purpose of even for the sake of repetition, so there is a formal process also. See, when we look into the regulations, we have seen that there is a formal process. After the base resolution plan is prepared, after the declaration by majority of directors is made, a special resolution by the members is made, and some other documents like up-to-date financial statements and recent financial statements are made and is shared with the financial creditors, then the applicant has a right under the regulations to convene a meeting of financial creditors, formal meeting for which the regulations are provided. So earlier also I said it is not something that you would run from door to door and pillar to pillar to all the financial creditors to look into his OTS proposal or look into his restructuring proposal, and there is no timeline for the financial creditors to consider that. However, in the case of PIRP, pre-packaged insolvency resolution process, the regulations are provided that even the notice can be served. Notice can be served to all the creditors, and the list would be provided by and that particular meeting, that would be the applicant. Applicant in this case can be the company, can be any of the director, or can be the CFO of the company, can be CEO of the company. So the applicant can call a meeting of the creditors, financial creditors, and the applicant can present base resolution plan, declaration, special resolution, other particulars, and he would ask them that this kind of restructuring would be uh, helpful in reviving the company. The financial stress of the company would be eroded in case this kind of resolution is approved. The banks, the financial creditors may say that no, we would like the resolution plan to be, base resolution plan to be better. So there can be modifications, there can be further conditions before they accept in principle the base resolution plan. The acceptance of in principle base resolution plan is not something, is an obligation on the financial creditors. Later on they may reject it, because in case nobody comes from the public to compete with the base resolution plan, then they can reject it. No, they don't want this base resolution plan, they actually want something more. So finally, the base resolution plan will compete with the resolution plan which is submitted by any person in public, and that time also the base resolution plan can be improved to a level which is acceptable to the committee of creditors. So that would be the final resolution plan. So the banks will never hesitate in starting this PIRP. Banks will never hesitate in giving this approval of 66% of the uh, financial creditors. So that's something which is process is there. And if the banks are not coming for the meetings, I think they would probably get some directions from government or from RBI that they should honor these meetings. Like we last time we also discussed what would be kind of a resolution professionals fee. So I would just reiterate that there are four things that we can try to settle as a fee. One is today we are interacting with either a chartered accountant, or we are interacting with an entrepreneur who is an MSME entrepreneur, and we are trying to guide them, we are trying to understand their financial position, we are trying to understand their restructuring proposal, which is called base resolution plan. We are helping them in preparing a base resolution plan, we are helping them in other formalities to be completed. So this is one part of the fee which definitely can be taken. Second part of the fee is the pre-PIRP role of RP. Once the financial creditors appoint you or any other RP, so that fee is also to be decided by the COC. So that is a fee where the RP is supposed to prepare a report and also supposed to do some other documentation, and the application will be consent will be given by the RP, and then the application will go to adjudicating authority NCLT. So that's just two roles. Once the adjudicating authority appoints the RP, then there can be a fee which can be lump sum fee for 120 days. Uh, so this 120 days is not extendable in this case. This 120 days is final. So in case there is no resolution plan is approved within 120 days by the adjudicating authority, then the entire process would be considered as the terminated. So the company will operate as it was operating earlier. So the see why this kind of existing system of CIRP, there are a lot of exclusions and extensions that we seek from adjudicating authority, and the reason is that the in case we don't do any resolution, then the company will be liquidated. So the consideration of adjudicating authority is that the company should not just go for liquidation only because the time is required, some more months or some more days are required. So that is the consideration. So in this kind of in PIRP, that consideration is not there. So in case you have not been able to do something which is to be done in a time-bound manner, then go back and run the company as you were running. And also to the financial creditors, in case you have not been able to take a decision, okay, live with it. But then there is no extension in such period. There is no provision for extension. So 120 days means 120 days. Otherwise, the company will go back. The company will continue with the promoters. The PIRP would be terminated. However, there is no liquidation. There is no loss to anyone. So in case this process fails, so the next turn will come only after 3 years. So the financial creditors will also think that in case we would not do anything, we will not get this opportunity in the next 3 years. In the meantime, somebody might even start CIRP for this kind of stressful company. So they would feel that it is better that we should handle this for financial stress now. Otherwise, in case this fails now, then they would not get this opportunity in the next 3 years. So like in case you understand the total scheme, it is beneficial to corporate debtor as well as to financial creditors that they should try to finally do something within this process. Otherwise, the not really good for anyone, because once this PIRP opportunity is lost, the financial creditors will also have a risk that somebody might even go for CIRP. In CIRP, they would have to provide much more provisions in their books of account. In CIRP, the promoters will also have to go for loss of management. In CIRP, there is no possibility that the company will go back to promoters unless their resolution plan is approved, or the company will go for liquidation. So all these circumstances are making a case that PIRP would be considered as much better than CIRP. It would be considered much better than OTS. It would be considered much better than the restructuring, which is done at the bank or financial creditors level. So I think we had attended in the last part 1 that how the applications can be made, how the process can be started. So today we are moving on to the next part. See, like from the public announcement, the regulations have also been announced. Form P9 is prescribed for public announcement, which is to be done in 2 days from the PIRP date, and there is no requirement for publishing in newspaper. The public announcement is to be done only in Form 9, Form P9, and this is to be done on information utility. It is to be done on the website of the corporate debtor, if any. And also, this public announcement has to be announced individually to all the creditors as per the books of account or as per the list of creditors provided by the corporate debtor to RP in Form P2. Form P2 has been given, and it's a detailed Form 2. It also provides for the contact details of the creditors and all the books of accounts, everything like the detail of. So this public announcement would not go to public, it will go to website, IU, and also to the creditors as per the list provided by the. Now, from this list of creditors, which is provided by the corporate debtor to RP in Form P2, that has to get now converted into list of claims. So from list of creditors, now the RP has to convert it into list of claims. So what is the process? The list of claims would finally be prepared by the RP, and that would be based on the list of creditors. When this communication will be sent by the RP to the creditors can finally come up to say that, yes, I confirm the balance that you are saying, or the creditor will say, no, there is a difference. So some creditors will say that, no, there is some other information, some other collateral security, some other guarantee, some other security interest. Everything can be challenged by the financial creditors, operational creditors, workmen, employees. All this can be communicated to RP. Then the RP will keep modifying the list of claims, and that list of claims would be regularly updated on the website of the corporate debtor, and that particular list of claim would always be available for inspection by creditors, claimants, corporate debtor, and the I'll just come back on this key. So then there is another information which is called preliminary information memorandum, and that information memorandum is almost similar to the information memorandum that we prepare in CIRP. So these two things would be prepared within 2 days of PIRP date. So why this is so? Why 2 days are given? Because the IBBI and the government expect that once you are selected by the financial creditors and application is submitted to the adjudicating authority, you have sufficient time to do all this kind of the work, which is the verification of the list of creditors from the books of account and other relevant information, so that you have to just say that the list of creditors now got converted into list of claims after my verification from the books of account, and after I have done my own analysis and my own verification on security interest, on the guarantees, and on any other matters. Now this is a regular process. The promoters and so like when this list of claims and the preliminary information memorandum would be submitted by the promoter, director, or partners, see, they are liable to compensate to every person who sustain a loss or damage because of any omission in the information or any misleading information. So this is very important, that the list of creditors or the list of claims which are supposed to be submitted by the corporate debtor to RP, there is an obligation to CD in this case, and that obligation is also leading to a penalty which may even get extended to 1 crore in case the information provided by the CD is incorrect. See, however, maybe there are some directors in the company who are independent, or they don't have any knowledge, they don't have any. So then you see, there is a protection like which say that no person shall be liable if the list of claims or the preliminary information memorandum was submitted by the corporate debtor without his knowledge or consent. So the provisions are made in such a manner that any person who sustained a loss or damage can approach a court having jurisdiction seeking compensation for such loss or damage, subject to the provisions of moratorium. The omission of the information or provide misleading information would be considered as an offense under section 77A. There is a newly inserted section which says that if the information provided by the corporate debtor is misleading or it is incorrect or there is an omission of creditors or liabilities, then section 77A would be invoked, which says that in case it is held that it has been done, then there is an imprisonment which can be minimum 3 years and maximum 5 years, and then there is a fine also, which is between 1 lakh to 1 crore. So this is the protection for the creditors, that the creditors should not worry that their name may not be there in the list. In case their name is not in their list and they actually suffer some losses, or they can come back to RP that my name is not there. RP can also take their name in the list of claims after verification. So when this RP should not consider that his work only will start once the uh, PIRP application is admitted in the NCLT and the RP is appointed by the NCLT. In fact, the RP has been appointed by the financial creditors with 66% vote, and the RP should start work from the day he actually has been appointed, only finally to uh, abide by the timelines given in the regulations and in the ordinance. The promoters are having a lot of duties in this process. Earlier, the most of the duties were only to cooperate with the RP, to provide information to the RP, but now the promoters have a lot more obligations. The board of directors shall continue to run the management during the PIRP period. However, the COC can put some conditions, like the COC can put a condition that for any transaction beyond a particular limit, or for any kind of transactions, maybe for example any sale of asset, maybe for example taking any further loan, maybe for example creating any further security interest on any of the assets, maybe for example making repayment to the related parties. All these things can be stipulated by the committee of creditor, that for any such transactions the board of directors will take permission of COC, not RP, COC. Now the earlier section 28 was there. Section 28, the resolutions are supposed to be passed and it was supposed to be presented by the RP and it was supposed to be passed by the committee of creditors. Now in this case, if there is any transaction mentioned under section 28 of the code, the corporate debtor will have to seek approval for the committee of creditors, not the RP. The corporate debtor will ask for this kind of permission, and the corporate debtor will provide for the resolution to be passed by the committee of creditors. So this is also now the duty of the board of directors is to protect and preserve the value of the property and manage its operations as a going concern. Earlier, it was the duty of the RP to keep the company as a going concern and also to protect and preserve the value of the property and the assets of the corporate debtor. Now it is the duty of the board of directors. The promoters, members, personals of the corporate debtor shall exercise and discharge their contractual or statutory rights and obligations in relation to the corporate debtor, subject to RP monitoring and other conditions of PIRP. They can continue with their all contracts, sale, purchase, whatever they are doing, whatever their operations are, and they would be under the monitoring of the RP. The RP would have all the rights. RP would have all the rights to visit the corporate debtor, to ask for the information, to ask for a monthly report or even periodic report. The RP can also ask for the kind of details of the transactions which can be stipulated by the committee of creditors. So all this information can be asked by the RP, but ultimately the responsibility to run the company as a going concern and the responsibility for taking any decisions of trading, that would lie with the board of directors and not with the RP. So very clearly, conceptually, I have actually understood the entire process. So this is much better. Like instead of creditor in possession, it is a debtor in possession. The responsibility is being shifted from RP to board of directors. The monitoring of the corporate debtor has actually been shifted to RP. The committee of creditors are more powerful, as even during CIRP also, and even now also the committee of creditors are more powerful. The responsibility which the RP probably was trying to do was the actual running the business of the corporate debtor. That running of the business is not required in the PIRP. So when we see the regulations 2021 and how the determination of the amount of the claims can be done by the RP, as I said, that CD would submit the list of claims within 2 days. The RP shall confirm the details received in Form P10 based on the records. RP has to inform to each creditor individually. The creditor may object. Now there is a 7 days window which is provided for all the creditors to object, and along with all these evidences and documents, and RP can also ask for more documents from the creditors. The RP has to maintain this list of creditors now, which is called list of claims, and all the modifications, everything has to be done. See, this is the format which is provided is P10. This is to be displayed always on the website of the company. It will be filed before IBBI electronically. It will be presented in all the COC meetings, and it will be available for inspections by the creditors, members, shareholders, partners, directors, guarantors. Where the claims are not purely concise or it is contingent, the RP can still make a best estimate of those claims as provided in the CIRP also. The additional information, whatever RP gets, the RP's duty is to get the list of creditors updated. Now, based on this list of claims or list of creditors, the committee of creditors will be constituted within 7 days of the PIRP commencement date. 7 days is too low. Within 2 days, public notice. Within 2 days, the list of creditors. RP has to work within 5 days to verify all the creditors. Verify in the sense, the word not used verification, but the word used is confirm. Confirmation and verification, how do you differentiate? I think it is only the confirmation word is used, but it is also used that based on the records of the corporate debtor and other material, other relevant material. This is the word used there. So confirmation based on the CD, books of account, records, and other relevant material. So to my understanding, it is almost verification. So when it is supposed to be verified and the committee has to be constituted within 7 days of the constitution, that means the 5 absolute days are available, not working days. 5 days are given after the list of creditors are submitted. So within 5 days, the entire the confirmation has to be done on the claims based on the records. So this is where I feel that this process has to be done before. So so when I say that the RP has to be engaged with the corporate debtor right from the beginning, that is one job. The RP should RP or any consultant can actually prepare all these lists, looking into the obligations of the RP, what records the RP would ask for the purpose of confirmation of claims. So if everything is kept ready by a consultant, he may be RP, he may not be RP, he may be a chartered accountant of the corporate debtor. So all this would be required to be presented before the RP, who is appointed by the financial creditors, and then only the timelines can be met. 7 days for committee of creditors to be constituted after confirmation of all the claims, because the committee has to be constituted. Now the the COC shall be altered on the basis of any updated list of claims, and all earlier decisions would remain valid. In case there are new claims comes or new verification, new creditors comes, and the verification is done by the RP, then the committee can be altered and the new committee can be constituted. First meeting of the COC to be held within 7 days from the date of constitution of the COC. So now the first meeting of the COC would be done within 14 days of the date of PIRP. First 2 days notice, next 5 days for the confirmation of the claims. 7th day the committee would be constituted, and the first meeting would be done within 7 days. The minimum 3 days notice is required to be given as per the regulations. The section 21 is applicable to committee of creditors, because like who would become creditor, who would become committee of creditor, who would be entitled to become a member of the committee of creditor, all that provisions are applicable to PIRP also. The COC had powers to ask RP for any information, and the RP was supposed to provide that. Those provisions are there, but now it is the corporate debtor who would provide the information to the COC and not the RP, because the company is under the control and management of the board of directors. So the board of directors will provide the information to COC, not RP. The related party to CD would not have any voting rights in the COC meeting. Provisions regarding authorized representative is there. It is all applicable. The class of creditor concept is applicable. How the class of creditors would be done? Like the class of creditor concept is managed in this in a manner. I'll just explain how the authorized representative would be appointed for a class of creditor. Now, recall that Form P2 is the list of creditors, and this is the list of creditor which is submitted to the financial creditors before even PIRP starts. So before even 66% of the financial creditors have given the consent to go ahead for the PIRP and make an application. So at that time, the RP is appointed by the financial creditors with 66% voting, and the list of creditors is given to the RP. Now the RP will look into the list of creditors, and RP will also look whether there is any class of creditors, and the number provided in the class of creditor is 10. In case any class of creditor is having numbers which are more than 10, then the RP will have to appoint an authorized representative for each class of creditor. So the RP will seek consent of the same class of creditors for the name of the IP to be appointed as AR. The creditor in class will provide their preference in 3 days to RP. RP will appoint the IP who is the choice of the highest number of creditors in that class. Then RP will inform the name of the IP such selected to the CD. Then CD will make an application to adjudicating authority. When the main application is being submitted, when the name of the RP is being given, along with the first application which is going to adjudicating authority, where the corporate debtor would say, corporate applicant will say that I please initiate PIRP for my company. I have 66% approval from financial creditors. I have the approval for the RP, and RP in turn has also communicated that the authorized representative process has been completed, the consent has been taken, the vote of the preference of the creditors have been taken, and that was all in 3 days. And this particular choice of the authorized representative would be submitted to the adjudicating authority along with the application. So that means when the order for PIRP is issued by the adjudicating authority, in that order RP would be appointed and also AR would be appointed in case applicable. So there is a pre-PIRP role, and this authorized representative is also a pre-PIRP role. So this, of course, there is a time available, but still the only 3 days time has been given to the creditors, and it will not be done. It will only be done through, it can be done over email, or it can be done even over kind of, if the numbers are more, then it can also be done over kind of e-voting, how to select the authorized representative if the number of creditors are higher and it is not manageable. So then it can be done on the e-voting formats also. So in case if only class of creditors and there is no other financial creditor, then the authorized representative will be the only COC. However, in case there are two or three class of creditors, like one class of creditors maybe for debentures, one class of creditors maybe for the deposit holders, one class of creditors maybe for allottees for a real estate companies. So there is a possibility that there can be three authorized representing each class of creditors, because authorized representative has to be appointed for each class of creditor, and you cannot merge debentures with the deposit holders and deposit holders with real estate allottees. So there can be a possibility that there is a one AR, there is no other financial creditor, so that one AR also can make COC. So now the process has been started. We've seen the pre-PIRP role of the RP. RP has done the report. RP has also selected the AR. RP has also done certain other formalities, and then the application is filed. The PIRP is ordered by NCLT. The claims are finalized. Within 2 days, the claims were submitted by the CD. The claims are finalized by the RP in 7 days. Committee is constituted within 7 days. The first meeting of the committee would be held in another 7 days. So that means 14 days. Now the 14 days have been passed, and the first meeting of the COC has happened. So in this first meeting of the COC, now we would have to see maybe the valuers are supposed to be appointed, and the forensic auditors are also supposed to be appointed, because this avoidable transactions, although there is a process where the CD will declare, and CD will declare if there is any avoidable transactions, and in the regulation form P7 is provided for the declaration under section 54C, which is to be given by the corporate debtor regarding the avoidance transactions under section 43, 45, 49, 50, 66. All these are avoidance transactions, and that would be provided by the CD in the shape of a declaration. So see, like in the valuers also has to be appointed. So the valuation, in case I have to just look into what the valuation provisions are, the valuation provisions are same as we have in the CIRP, but there is only one difference. That difference is that there is no concept of third valuer. Only two valuers would be appointed, and they would provide estimated fair value of the corporate debtor and estimated liquidation value of the corporate debtor. And the definition of fair value has also been provided in this case, which is saying that there should be kind of when we call about the proper time available, there is proper resources are available, the buyer is willing, the seller is willing, they have appropriate resources to market. So all these are conditions for kind of coming up with the fair value and liquidation value. So since the books of accounts are already available, the avoidance transactions, again the provisions are same. There are provisions like the RP will have to identify, form an opinion, identify the transactions, and then file a report, file an application to the adjudicating authority under section all this avoidance transaction. So while this process is going on, again this invitation of resolution plan would also be done. There is a possibility, there is an eventuality that has been discussed in the PIRP structure, that if because see, the RP is managing this, RP is only monitoring, the management is not being done, the operations are not being handled by the RP or the COC. And between, in case the COC is of the opinion that there is a possibility of misuse of this period. The CD may misuse the resources, assets. Then the COC can decide with 66% vote share and vest the management of the corporate debtor with the RP. That is only in case the COC is of the opinion that the operations of the corporate debtor is being conducted in such a manner that actually may be detrimental to the interest of the financial creditors or other creditors. Then in case the COC decides to vest the management with the RP, then it is the duty of the RP to make an application to adjudicating authority, where all this the COC's decision would be communicated, and adjudicating authority shall pass an order that the management of the committee, when management of the CD would vest with RP. And it is only in those cases where the adjudicating authority is of the opinion that the affairs of the corporate debtor have been conducted in a fraudulent manner. Second, there has been gross mismanagement of the affairs of the corporate debtor. So in case such situation comes up, then the RP will also start the control and custody of the management of the CD, and keeping the CD as a going concern would also be the responsibility of the RP. Now at this level, now again I will go back to scenario, how much the fees the RP will quote. First role is the pre-PIRP role, where I said that the pre-PIRP role we have seen, if the RP will file a report, RP will understand the financials, RP will also appoint an AR if required. All this has to be done by the RP, and then the application would be sent and along with the consent. So there is, till the time the PIRP order is passed by the adjudicating authority, the RP is having one role. So there should be one fee for this role, which will be approved by the committee of creditors. See, I'm still not talking about the role before this role, which is a consultancy role, which is a role where somebody will make the base resolution plan. Somebody would provide consultancy to corporate debtor regarding the possibilities under PIRP, regarding the process of PIRP, regarding what can be done under PIRP, because the regulation 44 has also been inducted, where what kind of measures can be taken by COC, what kind of haircut, what kind of concessions are in the powers of the COC, all that has been notified. So there is one role which is a consultant role, then there is a pre-CIRP role, then there is a PIRP role, where the management of the corporate debtor would not be vested with the RP. So as one understanding is that in this process, since the time is also restricted to 120 days, otherwise there would not be extension. So the extension provisions are not applicable. So then the PIRP would be terminated in case it is not successful. So there are some people they are saying that it should be monthly fee for 120 days, or some are saying that it can be a lump sum fee also. To my understanding, the monthly fee can also be done, but however, it should be very clear that these months of 1 to 4 months are not going to be increased, and within this period, the RP will have to do this as against RFRP. Now it is the IFRP instead of RFRP. Now it is IFRP, like invitation for resolution plan. Earlier it was a request for resolution plan. Now it is invitation for resolution plan, IFRP, evaluation metrics. As we in common language we say the Swiss challenge. All this is the responsibility of the RP. RP will have to do all this documentation processes. So this is very stressful 120 days, and this I believe it's not going to be extended. However, the monthly fees can be quoted. The COC should be liberal in such cases about the sanctioning of the fee, because the fee is not supposed to be paid by the COC. The fee would be paid by the corporate debtor. It is only decided by the COC, and rather there is an assurance in this case that whatever fee is decided and whatever expenditures are estimated, the corporate debtor will deposit that money in a bank account of the corporate debtor, which will be operated by the RP. So why this is being done? This is being done only because the RP should have the independence. RP should not connive with the CD. See, RP should not be begging for his fees to the CD, because the CD would provide a bank account and that money would be deposited in that bank account, and RP will make payment to the account to the forensic auditors, to the valuers, to the public notice people, to whatever fee, that whatever expenditure he is incurring, maybe be lawyer's fee, everything, that RP will be issuing checks from that particular bank account after that amount is deposited in that bank account with the approval of the committee of creditors. So the earlier the banks are presently the banks and the financial creditors are thinking that this is a costly effort. Everything has to go from the banks, and also when the CIRP comes and when the RP is supposed to take possession of the every business, of then the CD also make sure that nothing is available in the company, nothing is available in the bank accounts of the company in most of the cases. However, in this case, the CD would not think like that. CD will continue the way it is continuing. So this, the PIRP would be considered to be a better process in future.
You want to take some questions at this stage?
Yes, I think we should take the questions.
Yeah. So I have a question from an anonymous attendee, which is that what if the corporate debtor is not operational, generating such equivalent revenue which can finance the deposit of this money into that separate account that you're talking about?
Actually, the corporate debtor has to arrange this money, because see, there is no provision that the committee of creditors will provide for. Because the corporate debtor has to get approval of 66% financial creditors before the corporate debtor go for PIRP. So this may be one of the conditions by the financial creditor, that you arrange for the money which is supposed to be spent on PIRP. Then only we will approve your PIRP request.
So can it be actually brought in as a loan, as an additional capital by the promoter?
Whatever, because it is a company.
It can be anything. It
the
can
company
be anything.
belongs to the promoters. It is not going to go on anywhere. Yeah. Even if the PIRP fails, the company will be run by the promoters.
So the directors can bring in the money. It can be anything.
They can bring any amount.
Ashok Singhlaji is asking what should be the reasonable estimated monthly fee of the RP. I think it will depend on case to case. I don't think there is a standard answer to that.
No, so like we've already said many times in our webinars, there are 5 things that we need to understand. Like what is the total debt, total number of creditors, so that because its sensitivity increases in case there are 26 members in the COC. So in case there are multiple locations of the corporate debtor, then again all these assets are supposed to be monitored by the RP. So in case the amount of debt is 2 crores or 2000 crore, that also actually would increase the sensitivity. So these are the facts, the litigations, everything, of course. But then the fees should be much lesser than the CIRP fees, because there is no effort that you are putting in running the company, keeping it as a going concern, and the management is not in your control. It is a professional assignment. It is not for running the organization.
Do you see a possibility of having a fee structure where the RP proposes a different fee structure in case the exercise of the RP taking over the management is exercised by the
that's
COC?
What it is saying, because see the format, in case you see the format, it is the 3 kind of fee that's supposed to be quoted.
So
it is there in the regulation. It is already there in the regulation.
But then this fee that is held in security, that security will have to be provided also for that fee in case the management is taken over, right?
No. Like in case the management is taken over by RP with the resolution of COC, then it will be considered as the PIRP cost. It will be part of the PIRP cost. But still, it is not provided that the committee of creditors will contribute. It is provided that this PIRP, in case the management is taken over, and thereafter this amount would become if the management is taken over, then there is no provision that the management will go back. Either the resolution plan will be approved, so the entire PIRP cost will be funded through the resolution plan, or the company will go into liquidation, and this entire cost will become part of the PIRP cost and will be considered as the which will be recovered in the liquidation process. So once the management is taken over with the decision of the committee of creditors, then there is no way the management can go back to the CD. So that is considered to be.
So the fee is almost secure even in that case, provided the company has some assets. So that will then take care of that. So I am taking the
And if
most
the company
recent.
doesn't have any asset, then why the financial creditors will give at the outset approval for going PIRP?
Why will also the RP also take up that case where he feels that there is no asset involved? What is he protecting then? So all
Yeah,
that will
what
of
is
course
now
be
see
there.
like this particular PIRP process where the accounts has to be updated, all the balance sheets, audited balance sheets, provisional balance sheet till 14th day of the application. All that has to be there. And if it is not there in the application, then the application will never get admitted. So the entire details of assets and liabilities are to be provided. Complete
So
details, and there is a format given which even talks about the date of acquisition, cost, everything is given in that. It is a kind of an fixed asset register which is required to be enclosed with the application for PIRP to adjudicating authority.
So I'm taking the most recent questions. I'm assuming that most of the questions that were asked, about half an hour back have already been answered. In case not, then maybe those participants can repost their questions. Another question is, can we sell the assets during PARP?
Now, they see the management and control is with the CD. It is not with the RP. It is not with the COC. As I said, the COC would provide some conditions that for doing these transactions, the corporate debtor would take a prior permission from committee of creditors. I understand that the COC would also put a condition as guided by RPs that you should put a condition that no fixed asset would be sold without the permission of the committee of creditors. So the entire management, entire control, everything is with the board of directors. They have all the powers. It is the committee of creditors who would actually put a condition in the very first meeting that you would do this, you would not do this with the permission of the COC, without the permission of the COC. So the COC can always stipulate that you would not sell any asset during PIRP unless COC gives you permission.
Next question is from Mr. Vikram Bhatnagar. He's saying, can the right of recompense be incorporated in the base RP, or uh, and if so called other plans?
I think the question is come as a very, very somebody who has asked you a question has got an experience, because the recompense clause is provided in most of the restructuring proposals in the banks. So this recompense clause can also be provided in the base resolution plan. But the only question here is, when the base resolution plan will be compared with the resolution plan which is given by the public, then the public would not give any recompense clause, because the comparison of the base resolution plan will be with the plan which is given by public at large at an arm's length. So when a person who is coming to the company, acquiring the company, saying that I'm ready to give X amount for this company, and he cannot match with the recompense clause, he cannot say that yes, I would be able to recompense to the financial creditors after 10 years when I make money, or after 3 years when I make money out of this company. So that is actually like base resolution plan having this clause actually will have no meaning, because that is not comparable. No RA, no RA, and in RAs are called submitters in this case, no submitter of resolution plan would actually give this kind of option of recompense. So there will not be any comparison. So the COC would not accept the base resolution plan with the recompense clause. However, if the base resolution plan is accepted as such, if there is no uh,
Challenge to that
haircut,
plan.
if there is no haircut to operational creditors, then financial creditors has a power to accept base resolution plan where some haircut is offered and accepted by financial creditors with the recompense clause, and the same resolution plan is accepted, fair enough, because there is no public invitation in such cases. That can of course have the NCLT stamp and the unit is revived. But the only condition is that there should not be any haircut to any operational creditor. Then it is possible.
Mr. Viswanathan is asking what are the bank provisioning norms in case of PARP, CARP, OTS, restructuring when NPA, when standards. I think this is a very, very meaningful question from the point of view of bankers, that in case a company starts PARP and the bankers consent to it, do they have to provide for that borrowing?
So one, that we already have provisions of RBI for any, because this is called the IRAC norms, income recognition and asset classification norms of RBI. In that particular IRAC norms, it is provided about the uh, provisioning. Then for the CIRP cases, the provisioning is already stipulated. For liquidation cases, the provisioning is already stipulated. However, presently there is no guidelines, there is no circular from RBI which talks about PIRP. And we would definitely expect a circular from RBI regarding the provisioning requirement in case a company goes into PIRP. However, to my understanding, to encourage PIRP for MSME, the RBI will not ask any of the uh, uh, lenders to make any provision till the time the resolution plan is approved. Reason being, in case the resolution plan is not approved, PIRP is terminated, and the status of the company doesn't change. It goes back to the same promoters, and it is run as it was being run. So there is no change. So why should why should there be any change in the provisioning requirement? Because nothing has happened. I don't think there will be any requirement of provisioning for even PIRP initiation.
Yeah, I think we can also reread that the notification so that we understand in case it is general about admittance of a process under IBC or specific to CARP under IBC. Maybe
No, it is
that will
that
also
is under CIRP. There is
specific
no
to
reference.
CARP only.
Yeah, that is specific to CIRP as far as the RBI is concerned.
So another question from Mr. Galamudi, he's asking that in the normal restructuring, banks have to classify the account as NPA as per RBI guidelines. Are the banks required to make the account as NPA if resolution plan is approved? I don't think.
No. This is the first of all, there is no requirement that the account should be
Mm.
NPA for any PIRP to initiate. There is
So
only a requirement of
even
a default.
where a regular account is restructured, there is no requirement to mark it as NPA.
Yes. The
Mm.
restructured account, of course,
Might have some provisioning norms,
there
but
is a
then
requirement. There is a requirement
there is
of.
no NPA requirement. Provisioning requirements are separate. NPA requirements are different.
So provisioning
Yeah,
requirements are there for any
yeah.
restructured account,
Mm.
and those requirements definitely would be applicable if there is an account which is restructured. However, just by starting PIRP, I don't think there will be any requirement for provisions.
So how much time is given to RP to keep entertaining and verifying the claims? What should be the date on which the claim needs to be prepared and filed?
So there is no claim filing required in this case. The list of creditors would be provided by the CD. The RP would confirm the claims from the books of accounts and other relevant material. RP will send a communication to all the creditors that this is what the liability I have received in your name. And if the creditors come back and say that there is a difference, then it might require a reconciliation, and whatever would be the final, the list of creditors, which is now being called as a list of claims by this time, when it comes to the RP, that would be modified, and the committee of creditors also can be reconstituted.
So another question is, if the repayments to FC or OC are rescheduled over a period without haircut, will it be considered as haircut under the code as there is no loss, as there is loss in NPV?
Uh, the this is not significant because the base resolution plan can have haircut to the financial creditors who are voting in favor of the resolution plan. See, the only condition is that there should not be any loss to operational creditors, and that resolution plan can be accepted even without inviting any resolution plan from public at large. So try understanding what I'm saying. So base resolution plan, if the base resolution plan is not offering any haircut to operational creditors and it is accepted by 66% of the financial creditors, then there is no requirement to go to public at large for submission of resolution plans. See, that can include deferment, that can include even haircut by the financial creditors, that can include even working capital term loan, that can even include funded interest term loan, that can include any kind of restructuring, but it is restricted to financial creditors who are members of the committee, who are actually approving this resolution plan. If this is done, so that base resolution plan can be accepted without inviting anything from public. So that can include haircut, even reducing the liability, cutting the liability, so the changing the security. The regulation 40, the 44 is just like regulation 37 of the CIRP. All that can be done, whatever is provided in regulation 37 of CIRP, all that same things can be done in regulation 44 of PIRP. So the banks can accept it. No loss to operational creditors, no loss to workmen, no loss to employees, no loss to statutory authorities. The financial creditors have approved it. So that is not considered, whatever you consider it haircut or whatever, that is approved. So I think the question has arisen only because when I said that if there is any haircut to operational creditor, so this this question actually is getting generated because he thought because the haircut should not be there to the financial creditor also. So the financial creditor, if they can accept any haircut, that is what is acceptable.
So question from Ram Gupta, that is it applicable only to registered MSMEs or all or other non-registered?
It is accepted. Only, yes, Ankit can answer better than me.
So I think MSMEs which are not registered can register very easily, and after registering they can apply, so that there is no ambiguity on their MSME status. Udyam registration is a very easy registration to do. Maybe you can continue and then we can take more questions later.
Okay. So this, when the COC decides during PIRP that the control and management of the business would be taken by RP, then the residual section of section 14 moratorium would also apply. So the supply of essential goods or services like that also would be applicable. The this is the termination and suspension of interruption of these supplies. That is that particular moratorium would also be applicable. However, in PIRP, the moratorium subclause 1 and subclause 3 is applicable, but subclause 2 is not applicable. So that means that the promoters cannot say that the essential goods or services would continue even if the past dues are not paid. That particular moratorium is not open to promoters. It is only open once the management is taken over by the RP. Then once the management is taken over by the RP, then RP will take over all the management, all the powers of board of directors. Then the RP will take over control and custody of all the assets. Then all the provisions of section 19 and 20 regarding personals to extend cooperation and management of the CD as a going concern, that also would become applicable. The preservation and protection of the assets of the CD would become the obligation of the RP to take immediate custody and control of the assets. RP would represent everything before third parties, like RP will handle all the litigation. RP will appear before all the, or make arrangement for appearances and handling all the litigations. RP will be able to raise interim finance subject to SEOC approval. And this is again, as I said, for all items of section 28, RP will definitely get approval from the COC. We've already talked about section 77A, which is a prosecution section and also a fine section. So there is a new section which is 67A, and which says that on or after a PIRP, where any officer of the corporate debtor manages the affair with the intent to defraud creditors of the corporate debtor or for any fraudulent purposes, the RP shall file an application to adjudicating authority for imposing penalty, and that penalty can be between 1 lakh to 1 crore rupees. So now let us synchronize these section 67A and also in my previous slide the section 54J. Section 54J says that the COC has the power to take over control and custody of the management, and Section 67A says that the promoters would be also be fined and penalty would be imposed to them. So prior to this, we also have seen that the adjudicating authority shall pass an order so that the management should vest with the RP only in case the adjudicating authority is of the opinion that the affairs of the corporate debtor have been conducted in a fraudulent manner and there have been a gross mismanagement of the affairs of the CD. So these all the things together, so 67A and Section 54J taking over the control and management, this will prevent the corporate debtor to do any fraudulent trading or fraudulent intent during PIRP. So there cannot be an objective of applying for PIRP and also kind of doing some fraudulent transactions, because there are protections given, because the apprehension was that the India has seen various other laws like various kinds of restructuring schemes, the CDR kind of scenarios, or then the BIFR. All this has been seen in India, but whenever the debtor remains in possession, there are possibilities of misuse of the management's powers. But that deterrent has already been provided here. Section 67A and Section 54J has been provided to work as a deterrent so that nobody does that kind of trading transaction or fraudulent transactions. Okay, now we come to the approval of a resolution plan by Committee of Creditors. This the process that I would explain how this approval of the resolution plan by the Committee of Creditors would be done. The corporate debtor has already submitted base resolution plan to RP within 2 days of the PIRP commencement. So within 2 days means it was already prepared, it was already submitted to the financial creditors. The financial creditors have already kind of accepted base resolution plan, maybe with modification, maybe after modification. So finally, there is a base resolution plan which has been accepted by the financial creditors, and the PIRP application has actually been submitted, and the base resolution plan has also been submitted along with the application to adjudicating authority. The RP has to present the same base resolution plan before the Committee of Creditors in the very next meeting. The Committee of Creditors may provide an opportunity to the CD for revising the base resolution plan. Now the COC is completely in power to say that yes, now we are here to take a decision whether to accept or reject. Now we want that you should improve your base resolution plan, and the COC may invite prospective resolution applicants. That is something which is mentioned in the law. According to my opinion, the COC will actually do both. COC will ask the promoters to revise their base resolution plan and bring it to an acceptable level, and the COC will also decide that they will invite the resolution plans from public at large. So this process will actually be to ensure that the COC gets best value out of the process. Now when the resolution plan is like we are now talking about the resolution plan to be approved, all resolution plans and base resolution plans should comply to following requirements. These are the requirements which all the resolution plans should comply with, are prepared based on the information memorandum. The resolution plan or base resolution plan is submitted along with an affidavit that the resolution applicant is eligible under Section 29A. Now 29A is not applicable to MSME. Clause C and clause H of Section 29A is not applicable to MSME entities, MSME corporate debtor. However, other clauses of Section 29A are applicable, like willful default, imprisonment. These are the other clauses which are applicable, like the CD has failed into implementation of any other resolution plan. So other various clauses are applicable. However, the person who is submitting a resolution plan in PIRP should have all the qualifications. Then 29A is applicable to them. Then 29 is applicable to them. Even clause C and clause H is also applicable to them for all the persons who are submitting a resolution plan in PIRP. Same under section 53 section is applicable. The resolution plan must provide for the PIRP cost to be paid in priority. Then again, the operational creditors, whatever is due to operational creditor, that must be paid in priority over any payment to financial creditors. Then the any kind of payment to the debt of dissenting creditors is to be paid again in priority over other financial creditors, and the minimum amount which they would have got in liquidation, that is what should be provided in the resolution plan. The resolution applicant again would be entitled to attend COC meetings if interested. Here I said that the base resolution plan can be approved by the COC if no haircut is proposed for operational creditors. So that, yes, that is also possible. Then in that case, there is no requirement of inviting the resolution plans from public at large. So before I like to say, this is the protection to operational creditor. We'll come back to later. Now I actually will move on to a few. I will actually move on to some other the regulations that I have just prepared, and I will just sorry. Yes, this is what I wanted to say. Now when the COC decides to invite resolution plans from public at large. Now in this case, regulation 43 has been provided. The COC will decide, yes, we would like to invite resolution plans from public, and after the approval of the committee of creditors, the committee of creditors will approve 2-3 things. When a resolution plan has to be invited from public at large, the COC would decide about 3-4 things. One is that what would be the evaluation metrics, what would be the security, performance security, what would be the tick size. All this I will declare. I will come one by one. So this will reach here. So protection of I'll just take it again. The protection to the operational creditors will come back later. Now the COC decides that the resolution plan selected as per is significantly better than the base resolution plan. Now at this moment we have a base resolution plan which the COC is considering. Now the COC thinks that we have already got this base resolution plan improved from the corporate data, and we would also like to get it get the resolution plans from public at large. Now the COC has to decide that any resolution plan which will come from public at large, and that should be significantly better than the base resolution plan. Now, what is significantly better? That is also supposed to be decided by the committee of creditor. That can be based on the scoring system, and the COC can decide, like if the base resolution plan has a score of 50, the significantly better resolution plan should have at least 25% better scoring. That would be considered as a significantly better plan. All that has to be decided in this meeting only. What is the definition of significantly better? Then the COC will also decide about the criteria laid down for comparison with the base resolution plan and other resolution plans. Now this criteria can also be called as a valuation matrix, or this can be, you can take any name for this, but this is a criteria for comparing the base resolution plan with the other resolution plan which would be submitted by the public at large. So the COC has to select a resolution plan out of the resolution plans which are submitted by the public, and have to decide two things. One, which is the best resolution plan out of all the resolution plans submitted, and also should be significantly better than the base resolution plan. Now, finally, the COC has to decide, the COC has to only select one resolution plan out of all the resolution plans submitted by public at large, and that one resolution plan will be competing with the base resolution plan by whatever you call a Swiss challenge method. Although the Swiss challenge method is not provided, the name has not been taken in the ordinance or in the regulations or in the rules. But yes, the process has been defined how the competition will take place. I will come to that. The option 2 is that based on the criteria laid down, the resolution plan selected is not considered or approval or does not fulfill the requirement of subsection 10, that is the criteria laid down by COC, then the resolution plan selected would compete with the base resolution plan in such manner. I'll come to the regulation which has already come. This is called maybe Swiss challenge. One of the resolution plan would be selected for final approval, and that final approval, whatever the final resolution plan would be, that final resolution plan will be voted finally by the committee of creditors. So the entire process again has been summarized by me. The RP shall publish invitation for resolution plan. In short, we can call it as IFRP. When this brief IFRP is published in the newspaper, published in the way it is like website of the CD, website of the IBBI, and any other manner as decided by the COC. And the COC can also decide, okay, go ahead and publish it in the newspaper. COC can decide that. COC can certainly say that, okay, we would like to have more participation from the public, and we would like that it should be published in the Economics Times. So that is the COC's decision to whether to get it published or not. However, the Form P11 has been provided by the rules, which is for the brief particulars of the invitation, which is to be published either on the website of the CD or on the website of the IBBI or on any other manner. In that brief publication, it would also be mentioned that where the detailed IFRP can be accessed. Now, in the detailed IFRP, everything would be provided. Everything would be provided in the detailed IFRP. The resolution plans will be submitted. It is provided that it will be submitted within 15 days from the date of publication. And there is no provision for extension. There is no provision for extension or so even let us understand, one, that there is no provision for provisional list of PRAs, objections by PRAs, final list of PRAs are not there. The IFRP would provide basis for evaluation, like basis for comparing the resolution plans, parameters for significantly better. What would be the significantly better resolution plan? That IFRP would also provide for the performance security to be provided within the specified time as approved by the committee of creditors. IFRP would also provide for tick size. Now, tick size means that the minimum improvement required. See, whenever there is a process, like even today also, when we sell any asset through e-auction, we also provide what is the minimum enhancement, minimum increase that would be done by the bidders in each round. So that is what is called tick size in the regulations. The tick size can be, now in case the COC thinks that there are 4 things that can be improved in the resolution plan, and those 4 things can be amount of upfront payment to the creditors, amount of continued debt or staggered payment, the amount of like the loss which is being given to the creditors, the amount of investment which is being introduced by the company. So there can be many such things which can be improved in a resolution plan. So for all these parameters which can be considered in the improvement of the resolution plan, everything has to have a minimum improvement. So this minimum improvement is called tick size. Again, the same provision, there is no non-refundable deposits are not possible. The process of RFRP is not there. As I said earlier, that the provisional list of PRA, objections from PRA, final list is also not there in the process. So the resolution plans, now the resolution plan can provide for all the measures exactly the same as per the regulation 37 of the CIRP. Now the as against regulation 37, now we have provided regulation 44. That is the all whatever can be done by the committee of creditor, that the loan can be reduced, the term of the loan can be increased, the security interest can be changed, the company can be even demerged, it can be merged, it can be amalgamated. The mandatory contents of the plans are also the same as per regulation 38 of the CIRP. It's almost the same mandatory contents. Term of the plan also to be mentioned. The management and control of the business also to be mentioned. The supervision, like the monitoring agency, is also there same way. The again, as per the operational creditor shall be paid in priority if the amount is provided in the resolution plan, or if the liquidation value is due to operational creditor. The dissenting creditors also would have the priority over the other financial creditors, and the minimum amount offered to the dissenting creditor would be equivalent to the amount that they would have got in the liquidation of the company. So when it comes to the approval of the resolution plan, so resolution plan getting highest score as per the evaluation metrics shall be considered by the COC if significantly better than the base resolution plan. If no other resolution plan is received, then the base resolution plan will be considered for the voting. In case resolution plan with highest score is not significantly better than the BRP, then scores of the best resolution plan and base resolution plan shall be disclosed to RAs. In this case, it is considered as they are called submitters. So finally, the resolution plan with the highest score and the base resolution plan, these two people will compete with each other, and they would have right to improve the resolution plans by improving all the parameters as per the tick size approved. And this process is called Swiss challenge between the best resolution plan, which is received from the public at large, and base resolution plan. And this parameters can be improved, and it is to be improved within 48 hours. And probably this will be done on an online kind of e-auction process, and the companies will come up who will have this kind of technology where 3 or 4 or 5 things can be bid, improvement can be done, and finally the scoring also would be improved online. The scoring also would be improved online. So the one person will see that now what H1, my score is highest, so I would give the chance to the other person. So the technology will give the chance to the other person who actually has a lower score. Then whosoever has the lower score would keep getting the chances for improving the resolution plan, and either both of them say that we would not like to improve further, or 48-hour lapses. That would be the resolution plan which finally gets the maximum score based on the technology, which would, of course would be used by some of the technology companies. So this is what is called Swiss challenge. And in case the technology is not available, this can be done over a screen. This can be done over a screen which can be displayed. In fact, we have done various such open bidding processes where the resolution plans can be improved, and we have done it openly in the COC meeting by sharing a screen with all, and all the RAs are there. The difference is that in those cases even 3 or 4 or 5 RAs also compete with each other. In this case only 2 RAs are competing. One is the base resolution plan and the other is the best resolution plan. So this process can be done over a screen which can be shared with both, and again on an Excel matrix which can immediately convert the improvement into score based on the scoring system which is already defined. So Ankit, we can take some questions now at this level.
Yes, so we can. I was just waiting for that. So Sudhir, Mr. Sudhir Laj is asking what will happen if there are 100% OCs who are related parties to the CD in the base resolution plan. So he's saying all OCs are related parties. He's trying to ask what will happen to that base
So see,
resolution
like
plan.
first of all, he's saying that there is no FC in this case, and also he's saying that there is no OC which is not related party. Then I think in
No,
case,
I think we can answer both situations where we have some FCs and there are
no,
100%
say
of the
like I
OCs.
say like one, then case that we have the financial creditors, unrelated financial creditor will constitute committee of creditors.
Hmm.
Unrelated financial creditors will first of all approve the PIRP process to be started,
Hmm.
66% voting share. So that is the FCs. So in case there is no FC, then the operational creditors will do the same thing as FCs are done. In the CIRP case, 18 operational creditors were to be taken. In the same process, in PIRP, 10 operational creditors are to be taken, and entire powers of the COC would remain with the 10 operational creditors, and they would have all the powers as the financial creditors would have in a COC meeting.
So in a
However,
situation,
I could
okay, so in a
not.
situation where are no financial creditors and all OCs are related parties, I don't think a PRP is possible.
See, when there is no financial creditors and all operational creditors are related party, then why a person will be considered as financially stressed?
Yes. So we have a question from Mr. Ram Gupta. Here he says subsection 9. What is the meaning of significantly? It is the discretion of the RP or the COC. I think it is answered that it is discretion of the COC.
It is the discretion of the COC, and
And
this will be based on the score system.
So
He's
the only question here is that say a base resolution plan is signed or approved by the financial creditors, and during the base resolution plan, normally a financial creditor will be interested in a situation. A better resolution plan will be a plan where the money comes to the financial creditor sooner, or the money is higher. So if the so the idea is that the financial creditors can very conveniently say that significantly is 2% higher than what the promoter is was putting in the base resolution plan. So how does the promoter or how does the company's management get comfort that no, significantly will mean 5%? Because that will be a big ambiguity for the promoter or for the management to go into PIRP. They will be uncertain about how much better will the plan will be required to be for some alternative plan to be considered.
no. First of all, I may clarify that even the base resolution plan, if it is approved by 66% financial creditors before the start of PIRP, that would not be considered as approved during PIRP. So the see, like as I have already said, once the PIRP starts on the order of adjudicating authority, after that, the base resolution plan will be submitted before the committee of creditors again, and that by that time the committee of creditors can ask the promoters to improve it, and they can ask them for multiple improvements, and then in the meantime they will also decide, they will also pass a resolution what would be significantly better. So in case any resolution plan is received from the market which is significantly better, then also they can take a decision, no, we will still go for the competition. So this competition is basically the prerogative of the committee of creditors. They can get the competition uh, with the base resolution plan. And see, this is very important, Ankit. Significantly better means that the committee of creditor can even decide that if a resolution plan comes which is 50% better than the promoter's base resolution plan, then they would simply accept the resolution plan which is significantly better. Then the promoter will not even get a chance to improve. So this is basically why this has been introduced. This has been introduced so that the promoters should also put their best foot forward. They should not think that we should start with rupees 1, whereas the value of the property is 100. So they should also bring the best foot forward. Otherwise, the COC can say that yes, we have received a plan which is 50% better than your plan. So you are not getting any opportunity to get the company back. We are giving this company to somebody else.
And in all circumstances, the promoters or the management of the company will have more information as compared to anyone else in the public.
Yes.
So
So
that is a big advantage itself.
the
Yeah.
significantly better resolution plan, COC has the power without even going for the competition with the base resolution plan. That is a deterrent to the promoters that they should not give an offer of rupees 1, whereas the value is 100. They should give an offer which is much closer to the market value, so that the market should not actually give a resolution plan which is significantly better. That is something which is very significant, very important. If we see the understanding, if we see the structure, the way it has been made, so that the promoters should also not try to take the advantage of PIRP.
And all the other checks are also in place, that is the registered value are being in place. So all those checks will also check on the actual value or the fair value, liquidation value of all those properties. So I believe
Right.
that process will also have a role in the whole
Right.
process. Mr. Ashok Singla is asking, could you please elaborate on how to fix the tick size?
See, as I said, tick size, it all depends on the total value of the company. Suppose there are 4 items that you can improve. One, upfront payment. Second, you can say the induction of fresh funds. Third, you can say the continued payment. Continued payment. Fourth, you can say the total term of resolution plan. So the total repayment will be made in 5 years or 3 years. So next, you can say the so there are like there are many things. For example, there is the company which is a real estate company, and most of the creditors are home buyers. They can say that anyone who actually will give us the fastest possession, anyone who will invest 50 crores in the construction before asking for our own contribution. So there are actually based company to company, business to business, size of the company to company, there will be different separate parameters for tick size. So I can say if a company is only worth 20 crores, I can say that any improvement in upfront payment should not be less than 10 lakhs. And on the other side, if I have another condition, the term of the resolution plan, so I can say that the term of the resolution plan can be decreased by or increased just by 1 month or 2 months or 3 months. Or I can say the continued portion of debt or staggered payment of the debt that can be increased by say 20 lakhs in one improvement. So these are all tick sizes. Everywhere the tick size can be different. It all depends on the various parameters, size, business of the company.
Right. Another question is that I'll just come to that. Just a second. So if the COC can approve the base resolution plan, if there is no haircut proposed in the plan, what is the point of taking admission of PIRP, and just they could have just taken the nod of AA and gone ahead and not waste another 120 days. So I think the other processes are important, right? The process of valuation, the process of the FCs getting formed, the process of verification that all the creditors have been stated clearly. So all that is still required to be done, even if there is no haircut proposed. That
Yes,
would
you
be the
see,
answer to this question. The
if there is no
process has
haircut,
many checks.
no, yes, the process has many checks.
So those checks have
The
to be performed. Yeah.
it is never said anywhere that if the base resolution plan is acceptable to financial creditors, and if the base resolution plan is not giving any haircut to operational creditors, then the process would not be conducted. The valuation process would be conducted. The avoidable transaction process would also be conducted, and thereafter the base resolution plan can be accepted. And see, I don't think there is any uh, kind of misuse of the process which can be done, because the financial creditors are supposed to take loss. If they are convinced, then that's very happy. The financial creditors are approving that I want to take a loss, and why should the adjudicating authority or anyone else would have any objection?
Yeah. So an anonymous attendee is asking who all can pass the base resolution plan initially, and he's asking for the process. So I think the base resolution plan will be prepared by the CD. The CD will submit it to the financial creditors for their primary approval, and then once the approval is there, the CD will submit the base resolution plan along with the PIRP application before NCLT. Am I right?
Yes, you see, like this, this is the same. The process is the, I think here I would again say, because maybe that some people might have joined a little later. See, once this declaration is made by the majority of the directors, once a special resolution is passed, once a base resolution plan is prepared, and it is communicated to the financial creditors, all the financial creditors, maybe secured or unsecured, then thereafter the regulations have provided that the CD can invite, the CD can convene meetings of the financial creditors, and all the financial creditors will attend and they would discuss the proposal of the CD, and then they will take a decision. As I said, the process starts when this declaration of the majority of directors, I think in the board of directors, shareholders meeting, and the base resolution plan, this process starts, and the 90 days period starts now when the declaration is made. So after that, the application will be submitted to the adjudicating authority uh, for PIRP order. In the PIRP order, the RP would be appointed and the PIRP would be commenced, and the section 14 would triggered, moratorium would start. So then thereafter, the base resolution plan and the other resolution plans and the valuation, every process will be conducted after that.
So a question from from Hem Chandra, that if RP takes over, will it not become a CIRP? So I think the question is that if in a PIRP, the RP takes over the management, how is it different from the CIRP process?
Now, that's what I said, that the CI, it can be converted into CIRP. So then whenever the RP takes over the control, then it is converted into CIRP with the orders of the CO, with the orders of the adjudicating authority, with
So
the orders of the adjudicating authority. So there are two processes. One, that the taking over the control and custody, and that too with the uh, see, but see, there are two processes. One, the COC can always say that no, the PIRP is not working, so they can convert the entire process into, actually that is coming in my subsequent slides. Then they can convert this PIRP into CIRP. So then the period of 180 days and 270 days would be applicable in case it is converted from PIRP to CIRP. So the second process is that the adjudicating authority on an application by RP on a decision of the COC report to the adjudicating authority that the management of the business is being conducted fraudulently. So that's a separate process. These are two separate processes: conversion of PIRP into CIRP, and simply taking over the management control. And then again, the resolution plan can be approved. But in this case, in case the resolution plan is not approved, then the company goes into liquidation.
but in case the PIRP process continues instead of being converted into CIRP and the management was taken over by the RP due to fraudulent management, the PIRP will end and the management will go back to the
No, it will,
management of
they
the
see,
company.
like, then it doesn't go back, then it goes to liquidation.
So basically, one process is that the PIRP gets cleared and the management gets back the company with the resolution plan being passed,
No,
whatever the final
even if
resolution
the
plan
no,
is.
even if the PIRP fails, PIRP got terminated. See,
So,
but
so I'm
the only thing
hmm.
I'm referring to is that there is a fraudulent transactions by the promoters during the PIRP period.
So
Only
I'm
to
just trying to
prevent that.
conclude. I'm
Only to
just trying
prevent
to
that.
conclude the options. So one option is that one possible end is that the PIRP is passed and the management and the company goes back to the management because there is no contending resolution plan as the base or whatever the final resolution plan of the management is cleared by the financial creditors or by the COC. Number one. Number two, it is not cleared. Some Swiss challenge or some other resolution plan comes in, then the management changes and the company goes to the new management which has given a better plan. Number three, the management is fraudulent and that application is passed by the AA and the company goes into a liquidation in case the PIRP is finally not passed or the resolution is not passed by the COC. And the fourth one is where PIRP gets converted into CIRP, and then in that case the whole CIRP process will happen, and in case CIRP does not happen then liquidation will happen. The resolution is not found, then liquidation will happen, and that is what the process will be. So I think these are the ends
Rightly,
to, this
rightly,
is the
rightly,
conclusion.
rightly.
Um,
I think let me take these questions. I think most of it will be answered in the process. So
Yeah.
now this on this particular slide, I'm saying the resolution plan is not approved by the committee of creditors. So whatever finally be done, the committee of creditors could not approve any resolution plan. The RP shall file an application for termination of the PIRP. So the application for termination of the PIRP will be filed in form P13, and once the termination is approved by the adjudicating authority, then the company will continue the same way it was continuing earlier. However, if there is any application for avoidance transactions, that would continue. If the avoidance transactions are there, the company definitely will go back, but those would continue. Now, the approval of the resolution plan, as at the process of improvement of the resolution plan will be completed in 48 hours. The resolution plan having highest score on completion of the competition process shall be considered by the COC for approval. The process is now this process is generally called Swiss challenge, as I've already said. The As I said, the operational creditor and the dissenting creditor rules are applicable in this case. The other conditions of for approval of the resolution plan is that the 66% vote is required in favor of approval of resolution plan. COC will consider the feasibility and viability of the resolution plan also. The manner of distribution of proceeds under the resolution plan would be based on, again, the order of priority amongst the creditors as laid down in subsection 353, priority of security interest of secured creditors, value of security interest of secured creditors. The other requirements are not much. I've seen the regulations also. So in case the the other requirements are given in the regulation 45, like making statement of causes of default, cause of stress, everything as regulation 38. Similar to regulation 38, regulation 48 is provided in PIRP, and those are the same which are the mandatory contents of resolution plans. So in case the resolution plan proposes impairment of any claim, not restricted to operational creditors only, the COC will ask the promoters to dilute their shareholding or voting or control rights in the corporate debtor. In case no such dilution is proposed in the resolution plan, the COC may still approve the resolution plan, but after recording reasons for approval of the plan. Now, this is something which needs a little more deliberations. This is a situation where the impairment of the claims means haircut. If the resolution plan is giving haircuts to financial creditors or operational creditors, then the COC can ask the promoters to dilute their shareholding. The diluting shareholding means, although nothing is provided in the regulation, but then we can even add our experience and also practical possibilities. Diluting the shareholding, one meaning can be drawn that yes, the shareholding of the promoters can be diluted, and that part of the shareholding can be transferred to, can be given to the those claimants whose claim is impaired. This is one option which can be decided by the COC. The other thing which can be said, that in case the creditors are taking haircut, then the promoters also should lose control, and they should also sell part of the, or they should also bring investors. So they should also not have the control on the entire company. So they should bring some change in the management. They should bring some change in the shareholders. So that is what can be stipulated by the committee of creditors. However, it is not mandatory that always the dilution of shareholding would be done. The COC can approve a resolution plan. The COC can improve a resolution plan even if there is no dilution in the shareholding. However, they have to record reasons like why this particular option was not exercised by us. So this is till this time we have now considered how the resolution plan would be approved by committee of creditors. We have also discussed the competition, which may be called a Swiss challenge. In case the technology would not be available, it can be done over Excel by the RP, and it will be done completed within 48 hours. The dilution also, the change of management also has been discussed. Now, when the NCLT will approve a resolution plan, what would be considered by the NCLT? First of all, the RP shall submit the resolution plan as approved by the COC before adjudicating authority, and it has to be submitted within 90 days. The adjudicating authority will satisfy itself that the COC has approved the resolution plan. If it is without any haircut to operational creditors, the adjudicating authority will also satisfy that the COC has approved the resolution plan under section with the haircut. So without haircut and with the haircut, the resolution plan complies with the conditions of 30 subsection 2, means operational creditor and the dissenting creditors. Although it is written that the adjudicating authority shall approve a resolution plan within 30 days from the receipt of the resolution plan by passing an order, but this 30 days may not be considered as mandatory, because we already have seen in the case of CIRP, the whatever timelines has been given for the adjudicating authority, that actually has been considered as directory, not mandatory. So that depends upon the objections which may come from various parties on the resolution plan. That also would depend upon the capacity of the NCLT. That also would depend upon the time availability of the bench. So all these things will actually would be seen later on, but presently the 30 days is provided in the Act. The adjudicating authority shall ensure that the resolution plan has provisions for its effective implementation. Resolution plans once approved by the adjudicating authority shall be binding on the corporate debtor. It is the same provision as we have seen in section 31 of the code, that it will be binding on the employees, members, creditors, grantors, central government, state government, local authorities, or any dues including statutory dues. It is binding on everyone. The adjudicating authority can also reject a resolution plan. Of course, it is written within 30 days, and if the requirements are not complied with, and this is what is the approval of the resolution plan. Vesting of the management with the actually, when this management of the corporate debtor is vested with the RP under section 54J, based on the fraudulent and gross mismanagement by the promoters, then the resolution plan can be approved. And if it does not change in the management, then the adjudicating authority shall pass an order rejecting the resolution plan. So once the COC puts an allegation that there are fraudulent manners and gross mismanagement by the promoters, and again the COC approves the resolution plan which is given by the management without any change in the management, then that resolution plan will be rejected by the adjudicating authority. Then the adjudicating authority shall terminate the PIRP and shall pass an order to liquidate the company. As I said, that once the management is taken over by the RP based on the fraudulent and gross mismanagement allegations, then the company can only go to third parties if a resolution plan is approved. If it doesn't go to third parties or a resolution plan is not approved, then company would be liquidated, and all the PIRP cost shall be included in the liquidation cost. All the PIRP cost shall be included in the liquidation cost. The section 54M says that the any person aggrieved by the order approval of the resolution plan may prefer an appeal before NCLAT. The approved resolution plan is in contravention of the provisions of the law for the time being in force, or there has been material irregularities in the exercise of the power of the RP during these are the things that actually are used whenever there is an appeal which is filed before NCLAT, and these are the various this is already provided in section 61 subsection 3, so this is not new to PIRP. This is actually even the present section 61 subsection 3 is applicable for filing any appeal before appellate authority. The termination of the PIRP, for termination, the RP files an application for termination of the PIRP if all the resolution plans are rejected by COC, including the base resolution plan. So the base resolution plan can also be rejected by the COC. RP files an application for termination of the PIRP because no resolution plan is approved by the COC within 90 days. So if 90 days are crossed, then again RP can file an application for termination. The adjudicating authority shall pass an order within 30 days of such application, terminate the PIRP, and provide the manner of continuation of proceedings under section 43, 45, 49, 50, and 66, and also 67A. So this is the provision that I was referring to, that in case the determination of the PIRP can be done, but the proceedings initiated under section 43, 40 avoidable transactions, that would continue, and the adjudicating authority would provide a manner in which the proceedings would continue. RP also can, the COC can also take a decision that there is no possibility of a resolution plan, so the PIRP should be terminated. So that's possible. The PPIRP can be terminated with 66% voting, and the application would be submitted to adjudicating authority for termination of the PIRP. The fee and expenses of the RP, that is the entire PPIRP cost, shall be borne by the CD if the order is passed by the adjudicating authority for termination. The entire cost will be borne by the by the company in case the termination is done. If the management is taken over, by the RP based on the decision of the COC and the adjudicating authority, and no resolution plan is taken over, no resolution plan is approved within 90 days, then the adjudicating authority shall pass the order for liquidating the company, and the entire cost and expenditure that would be considered as the liquidation cost. Now this is the section which talks about the conversion of PIRP to CIRP. This is also the power of the Committee of Creditors to convert PIRP into CIRP, again by 66% vote. The CD, this corporate debtor must be eligible for CIRP because of the default amount applicable to PIRP is 10 lakhs and the default amount applicable to CIRP is 1 crore. So that threshold limit must be available for converting a PIRP into CIRP. RP's duty is to intimate the decision of the COC to adjudicating authority to convert PIRP into CIRP. Adjudicating authority shall pass an order within 30 days to terminate PIRP and to initiate CIRP. This 30 days, again, the same story. RP shall be appointed as the IRP subject to submission of written consent. Now, the same RP who was doing the PIRP would be appointed as IRP now in the CIRP process of the company, and any PIRP cost incurred so far shall be included in the CIRP cost of the CD. I think very clear. So the conversion of this PIRP to CIRP, if the RP is not giving any consent for CIRP, then the adjudicating authority shall take the name from the IBBI. I think the panel that is made with the NCLT, the adjudicating authority will pick up the name from that panel. Then CIRP would be considered as CIRP under section 7. CIRP shall commence from the date of the order. The proceedings under section 43, 45, all the award extensions shall continue during CIRP. The look back period as provided in section 43, 46, and 50 shall be reckoned from PIRP date in case of conversion from PPIRP to CIRP. So this look back period should not be delayed. For the purpose of look back period, as provided in section 43, 46, and 50, that will be reckoned from PPIRP date and not from the CIRP date. So till this, I have already almost completed. I'll have 2-3 slides more, and then we would see the questions, Ankit, in case we have it. Some of the sections, some of the existing sections of the code would be applicable to PIRP also. Like section 24, whenever it is referred as members of suspended board, that is changed to members of the board. The filing of the avoidance transactions applications would not affect the proceedings. the section of section 27 would be applicable. That means the RP can be replaced by COC during PIRP also. Within 90 days, the RP can be changed. Section 27 is applicable to PIRP also. All the clauses of section 28 are applicable to PIRP. So wherever the any activities which is provided under section 28, instead of RP taking permission from the COC, the CD will take permission from the COD. Otherwise, those transactions will be considered as void ab initio. Appeal provisions like section 61, this is applicable under section and for PIRP also. All the offenses and punishment, section 74 is also applicable. For the contravention of moratorium, section 74 is applicable. Liquidation order can also be appealed against based on the material irregularity or fraud committed in relation to the liquidation order. Order passed by the adjudicating authority for conversion of PIRP to CIRP can also be appealed against. Like section 67, which is like fraudulent or malicious initiation of PIRP, that is also applicable. These two sections, 67A and 67A, that I have already explained. Now, I think one little time may be spent on what would be the contents of basic resolution plan. This is based on my experience and reading of all the regulations and the ordinance. Details of the corporate applicant, whosoever is a corporate applicant, individually or jointly. That is the base resolution plan. Then the details of the corporate debtor, history, nature of business, causes of stress, particulars of any application pending under section 7, 9 or 10, complete details and basis on which the CD is MSME, along with the documentary evidences. The complete details of default under section 4 of the code, for which amount of rupees 10 lakhs has already been notified. Statement and evidences that the CD is eligible under section 29A. Analysis of the financial statements of the corporate debtor for the last 3 years, along with the copies of the financial statements. Particulars of declaration made by majority of the board of directors. Particulars of special resolution passed by the members of the CD. Particulars and the consent of the proposed RP. List of claims in the format as may be prescribed, which is already provided. It is the P2. Declaration on avoidable transaction, that is also part of the base resolution plan. Particulars regarding eligibility, that I've already said. Feasibility and viability reports like projections for the entire period of the total repayment of debt. Though this is called the business plan. Projections and also how the unit would be revived, the capacity utilization, any additional investment required, how much would be the EBITDA, how much would be the cash accruals, what would be the debt service coverage ratio, how the debt would be serviced, what would be the current ratio. So this is all what would be a base resolution plan. So the documents which are actually required to be submitted along with the base resolution plan is the constitutional document, financial statements of the company, contingent liabilities of the corporate debtor, preliminary information memorandum, list of assets and liabilities as on the PPIRP date, details of the business operations for the last 2 years, updated books of accounts are also required. Now I have reached, Ankit, to the basic definition of MSME, which is the investment of 50 crores in plant and machinery and turnover of 250 crores.
Up to
250 crores. And then there is a requirement of complying with both the conditions of investment in plant and machinery and turnover. And now it is also very important to see what is the calculation of investment in plant and machinery and equipment. So as per the notification of MSME Ministry, the calculation of investment in plant and machinery or equipment will be linked to the income tax return of the previous year filed under the Income Tax Act. If it is a new unit and there is no income tax return filed so far, then the value of plant and machinery would be taken as per the invoice without GST. Now the definition under the Income Tax Act, which is used for plant and machinery, that includes everything other than land and building and furniture and fixture. Now the benefit is the plant and machinery includes all kinds of equipment, electrical fittings, vehicles, trucks, buses, ships, aeroplanes, software, books and professions, even cars. So now the plant and machinery includes everything other than land and building and furniture and fixture as per income tax law. Now the value of plant and machinery which is to be considered, that would be return on value. Now this has been clarified by RBI circular. See, because see, what is the logic? The logic is that the MSME ministry says that the value of plant and machinery will be picked up from the income tax return. See, when we go to income tax returns, there is no column for gross value of plant and machinery. In the income tax return, it is only the return on value of the plant and machinery. So the RBI circular dated 21st of August 2020 has clarified that the plant and machinery would be considered as return on value, which is provided in the income tax return. However, it also says the Ministry of MSME says that the cost of pollution control, research and development, industrial safety devices, and such other items as may be specified by notification shall be excluded. There is also a notification, and that notification is somewhere given in 2005, and that is still valid. In that notification, even the molds and dyes are also excluded. That notification also is significant. So this is what is the kind of definition of plant and machinery. So it's very, very careful that every year the definition changes. Every year the value of plant and machinery will change. So this is required to be uploaded and updated every year on the MSME portal. The turnover also has been defined. The turnover will be taken as per the Income Tax Act and as per the GST law and as GSIN. So the turnover would exclude the export turnover, export of goods or services would be excluded. Now, in case a company is there which is doing a turnover of 200 crore, domestic turnover of 200 crore and export of 1000 crore and has an investment of less than 50 crore, that also is an MSME because export turnover is to be excluded. Domestic turnover is less than 250 crores. So that is also an MSME. So the turnover related figures such as enterprise, so this is something which is very important, that registration is mandatory. Without registration, it is not possible to go for, because the registration is required to be attached along with the application, which is supposed to be submitted in Form 1, which is provided in the rules, which is already notified on 9th of April. So the Udyam registration online should be used. The process should be repeated every year. It should be, the figure should be updated. So in case we don't do that, we may lose the status of MSME. And in fact, everyone was required to do that up to 31st of March 2021. So in case nobody has done that, everyone is required to do it. So this is what I believe. I have also done some kind of work on the what are the opportunities for the professionals, the chartered accountants, advocates, company secretaries. The banks and financial institutions would always be interested in restructuring under this structure because of the market value approach. The lenders will prefer this approach as most of the times the PIRP cost will be borne by the CD. The CD would also prefer this route as it is less expensive, less intensive, lower stigma in the market. It will not disrupt the operations. This is faster and quicker. Proper checks and balances have been built in the process, and this is what the financial creditors will consider, so that they'll go by this. The CD will prefer this process to circumvent the pressure of multiple applications under Section 7(9), because it is already provided that in case this application is pending, no application under Section 7 or 9 can be considered by the adjudicating authority. So valuation, I've already discussed. The valuation would be done in what manner. Opportunity of the professionals, as I said, the RP will get fee from the CD for a pre-appointment role also. RP will work on base resolution plan and preliminary information memorandum. Professionals other than insolvency or insolvency professionals can also take up assignments and appoint an RP after in principle decision are taken by the FCs. Mergers and acquisitions of those companies with some financial stress can be handled under PIRP. Sale of business can also be routed through PIRP, because there is a protection, there is a seal of the insolvency, there is a seal of adjudicating authority. So these are all my presentation. Ankit, we can take up some questions for another 10 minutes. Already we have, because we started 5 minutes late, so I have deliberated for 2 hours, 5 minutes, but we can take questions now. Final question that we can take till the time we are okay with the, still we have most participants are still connected with us. So we can actually take up some questions, Ankit, now.
A question from Naresh Munjalji came at 8:10, so a while back. So he says that if the RP forms an opinion that there are puff transactions that have happened, who should he report to? He should report to AA through the COC, or he can directly apply to the AA from the
No, there is
IP.
no COC required in this case. He can directly
Yeah.
apply to AA.
So the very similar to the way he does that currently.
Absolutely.
And another question is, can CRP, which is initiated under Section 10 of IBC, be withdrawn by CD, and then the CD can initiate an action in PIRP? I think yes. There is no bar
Yes.
on withdrawing a 10
So
application.
after all the applications are disposed of, section 7, 9 or 10, then PIRP can be started if all the applications, if the existing applications are pending.
Yes. Mr. Iswaran Pillai is asking if Regulation 31(1) in the proviso, it is mentioned as COC may modify percentage of voting share for quorum for any future meeting. Could you please clarify and how it is going to affect 35 of regulation on voting for committee?
Now, see, there are circumstances like I'll tell you the COC. There is a possibility there are two creditors only, and both of the creditors are having say 40-60% shares. So then the COC can definitely decide that no decision would be taken if both of us are present in the subsequent meetings. Although the regulation says that the 33% voting share is required for a quorum for the quorum of the meeting, however, the COC can definitely protect such circumstances where there are only 2 or 3 people and all of them know wants that all of us should be there when any decision is taken or when any meeting is conducted or for any resolution. So this is a very critical circumstances, which is like very clear circumstances when there are 3 or 4 people and they decide amongst themselves that in future we will not take any decision if any at least 3 of us are present. So this is very normal in various shareholders agreement also. You would probably see that such kind of quorum requirements are mentioned, that without the presence of investor, without the presence of minority shareholders, the resolutions would not be passed. That I have seen in various shareholders agreements. So that's a decision of the committee of creditors.
Mr. Ashish Mehta is asking that how the jurisdiction of the courts. So he's asking that who will decide on the claiming damages part, and how will the jurisdiction be decided. I think NCLT jurisdiction is very clearly on the
I
registered
don't think,
office.
no, I don't think this is an NCLT issue. If
Mhm.
there is any damage
Hmm.
to any person and he is not supposed to go to NCLT, he will go to any other appropriate court. But that is only in the case any creditor is having some incurred some damages of not including his name uh, into the list of creditors.
So
He can go
Mr.
to any other
Pillai,
court.
so Mr. Pillai is asking a further question, that will it override the code? So if it is provided in the code that
Yes, the
the
code
code
says
provides for it,
33%, and the code provides itself that the
provides
COC
that,
has the
so if
power
the
to,
code provides, it can be enhanced.
it can be enhanced.
So then the question is, to complete the forensic audit to arrive at some conclusion within given time is ambitious. So some way to clarify
Very ambitious,
feasibility and viability of
very.
COC and independent agency report will be required. How to ensure this timeline? So I believe the major problem with forensic audits are that information is not available, and the delay in information causes a lot of delay. So in case the information is available, then perhaps we can be optimistic that the forensic audit will be completed sooner.
Also, the mere application,
Mm.
also the mere application, there will be a declaration under section 54C from the promoters regarding any possible avoidance transactions, and that for that even a form is provided. Form P7 is provided for that. So most of the information, part of the information would be available even at the application stage.
And
So the
maybe
RP only have to work a little bit on that.
So maybe
It
the
is also
COC
not
will,
yes,
the COC will also feel better or feel more confident in passing a resolution plan from the promoters in case they have a clean forensic audit report. So I think there is a lot of incentive for the forensic audit to be done in time, or the
no, see, first
information
of
to
all,
be available.
let me be very clear. Even during CIRP, there is no regulation, there is no act, there is no word of forensic auditor to be appointed. That has never been used. So it has become
Transaction
a
audit.
tradition. It has become a tradition during CIRP. The only responsibility is with the RP. RP has to form an opinion, RP has to determine, and RP has to file an application. These are the three stages. And most of the RPs are not ready to take this responsibility that they have formed an opinion, they have determined. So for the purpose of forming an opinion and determination, they need a help from a specialized trained person. So that is what is called forensic auditor. So not specialized trained person, it is similarly in PIRP structure also, it is not mentioned that the RP is supposed to appoint a forensic auditor or a transactional auditor. It will become a tradition that it should be appointed. That's what is my belief.
We have a question from Mr. Subramanian. He said that what will be the approach in case of closed companies? Will the financial creditors take the initiative of a PIRP and going through the process? I think if there is any valuation for the FCs in the PIRP, even for a closed company where maybe the promoters are offering more
No, I
than what the
think
FCs will be able to recover in case of a
no,
normal recovery process.
I can give you an example. Suppose a company is a closed company, and there is an investor now, and there is a buyer who actually is who want to run this company with the some kind of support from the promoters. So he would like to take over 90% or 100% or whatever. So then then the promoters can submit a base resolution plan that my company is closed. I have found an investor. So he is interested in reviving the company. So he is contributing this much of money. However, he needs protection from the operational creditors. He needs protection from the statutory liabilities. So that actually can be a very good deal for any person who want to buy a company which is closed. Very, very important. That's the best scenario for PIRP.
Right. So, Sushil Agarwal is asking that Regulation 7 also speaks about appointment of IRP. Your views on this provision?
The IRP only would be appointed in case the PIRP is converted into CIRP. If the PIRP is converted into CIRP, then only the IRP would be appointed. Otherwise, there is no requirement of appointing IRP in PIRP structure.
So I believe I'm done with most questions. Maybe somebody whose question is not answered can repeat it. But I think we are also at 9:18 now. So
yes, I think we should now, it's
wind
a
up.
time to say thanks to all the participants. And as I always say that there is no other objective. The only objective is the my way of learning. So we are learning with the questions that you ask, and we will keep learning from all of you. This particular video would also be uploaded on our YouTube channel. So please do visit in case somebody is missing any link, any point, and you can even come back to us for any kind of question that comes in your mind. I will try to respond to all that. So we should convey our gratitude, our thanks to all of you. Thank you very much.
Thank you, everyone. Thank you so much.